An Arkansas woman will appear before a judge next month after police say she allowed a man to abuse her own young daughter. We're going to dig into how the alleged abuse was discovered and the wholly inadequate response police say Kelsey Ann Ezzy had to her daughter's suffering. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. 26-year-old Kelsey Ann Ezzy posted a $2,500 bond this week on a felony abuse charge. Now, it wasn't because she allegedly directly abused anyone. No. Rather, from the allegations from the police in Hot Springs, Arkansas, they say that she let a man physically abuse her own daughter. Yes, this apparently even after being told by social services that she couldn't be around this guy. Now, according to a probable cause affidavit, a Hot Springs police detective gets a call on the child abuse hotline, which reported that that man, who was known to police, was allegedly abusing a young girl. And the girl, who, by the way, her exact age is not known, but allegedly had more than 20 bruises on her arms, her hands, her legs, 20 bruises. And while police say they know this guy, the suspect, they've had dealings with him before, but to be clear, he hasn't been publicly identified, so we don't know who he is. But the next day, a caseworker from the Department of Human Services does an inspection of Ezzy's home. And she told Ezzy that this male suspect couldn't have any access, any contact with the victim, that he wasn't allowed in the house, that Ezzy wasn't allowed to contact him. And according to the affidavit, Ezzy said she understood that she would stick to the rules while an investigation was done, but not long after, the girl apparently had new bruises on her arm. An investigator with the Arkansas State Police Crimes Against Children Unit went with a Hot Springs officer to do a forensic interview with Ezzy's daughter. And according to investigators, the girl told the detective that this man squeezes her arms, and she showed the investigator the bruises. She reportedly said that the suspect, quote, is mean to her and pushes her down. And when the detective asked her if her mom, Ezzy, knew about the bruises, the victim said that her mom told her to tell anyone who asked, the doggy fell on me. By the way, as you can see, the content that we cover here on Sidebar just shows you that the world is not a safe place. And especially, you know where you think about that a lot? Your home, right? That's the place you need to protect the most. And did you know that right now, home title fraud is just rampant? Yeah, I didn't know it. I met with the people over at Home Title Lock, our partner and sponsor, and I'm not going to lie to you, freaked me out. This is an example of a fraudulent quitclaim deed. So it got filled out with my information, forged signature, fake notary seal. Not only can my property just be transferred behind my back, but the scammers, they go after the equity. They take out loans using your home as collateral. And they do all this, they disappear. You're left with a legal and financial nightmare, but that is where Home Title Lock comes in. They give you peace of mind, especially with their triple lock protection, because that gets you 24/7 monitoring, alerts of any changes, and restoration services at no out-of-pocket cost to you. So to protect your home, go to HometitleLock.com/sidebar. Use our promo code Sidebar. You'll get a 30-day free trial of their triple lock protection and a free title history report to make sure you aren't already a victim. Now, if we take these allegations as true, what makes matters even worse is it turns out that this suspect, this guy, was living with the girl and her mom in their house. She told the investigator that he'd been there when she left for school that morning. Photos of multiple bruises were taken and a warrant was issued for Ezzy's arrest on a charge of permitting child abuse. This is a Class D felony in Arkansas. That's our understanding. And according to the Arkansas statute, this is when a person commits the offense of permitting abuse of a minor if being a parent, guardian, or person legally charged with the care or custody of a minor, he or she recklessly fails to take action to prevent the abuse of a minor. It is a Class D felony if the abuse is about consisting of sexual contact or causing physical injury to a minor. And by the way, it's our understanding that Ezzy faces up to 6 years in prison if she's convicted. She was released, as I mentioned, on that $2,500 bond. She's going to face a judge just before Christmas. But I want to talk about this, and I want to bring back in here on Sidebar Professor of Law Marian Braccia, who is a practice professor of law at Temple University and also the director of the LLM in trial advocacy. Professor, thanks so much for coming on. Just your initial thoughts about a case like this.
Thanks, Jesse. Good to see you. Thanks for having me again. My initial thoughts and my initial reaction to a case like this is it's just so unfortunate that these are such common scenarios. with child abuse cases that could be prevented with greater adherence and greater oversight, given interagency involvement and adherence to the rules and any findings that are made by social service agencies. And it's just such a sad scenario for the child who really needs an advocate at this point.
One of my main questions after looking into this story was there seemed to be an awareness, knowledge that this girl was in danger, that she had been abused, that do not allow this man anywhere near her. And we just have to, I mean, you take the allegations as true, just take the mother's word for it that she's going to make sure he doesn't come back. Is there any resources, any avenues by which, law enforcement or social services could have come in to prevent something like this from happening? Or is it just you hope for the best and you pray that the worst doesn't happen?
Well, it shouldn't be a hope for the best situation. It really should be a scenario where all of the agencies that we've talked about, law enforcement, Department of Social Services, the family courts, the court system, dependency courts, are able to safeguard this child and make sure that she is safe, that she is being cared for, that she's certainly not being abused. But it really does require collaboration and cooperation and a lot of communication between those individual agencies. And again, it requires follow-up and follow-through from the social workers, from the caseworkers, from the Department of Social Services to make sure that this child is in a safe and certainly not abusive atmosphere where she's potentially exposed to further abuse.
Now, to be clear, these are allegations, right? She hasn't been found guilty. But how would prosecutors prove this?
So any case that involves a child witness is a particularly sensitive case. And I think prosecutors are eminently aware of the potential for traumatizing a child even through the court process. So those are considerations that need to be taken. Do we want to re-traumatize or cause any lasting emotional effects on the child from having participated in this prosecution, having testified against their mom? That's a really difficult thing for a kid to go through. But another consideration that the prosecutors, I'm sure, are taking into account is the fact that this is a child witness. Now, again, we don't know how old the child is, but there is a concern regarding competency as a witness. And that means that depending on how old the child is, the prosecutors would have to prove before they present her testimony that she's competent. That means that she understands the importance of telling the truth, that she understands the difference between a truth and a lie, that she can relate and recall events that have happened in the past and report them with accuracy and with detail, that she understands the difference between fantasy and fiction to make sure that when she is offering, if she does offer live testimony, that it is something that is credible and competent as is required by any witness who takes the stand.
You mentioned something so key there, if she takes the stand, because we were talking before you came on that this state, as well as other states, there's a specific way in which you can get that testimony in without having, let's say, however young she is, without having this daughter, this alleged victim, having to take the stand. Can you explain that to us?
Right. And there is an exception in Arkansas, the rules of evidence. Now, in Pennsylvania, where I live and practice, the exception to that hearsay rule is called the tender years exception. And Jesse, as you know, in this country, we have a saying, when you have something to say it in court. And so that's why we prefer, as a legal system, direct evidence. We want witnesses to come into court, say what they themselves experienced, what they themselves observed and perceived. And we want them to be examined, cross-examined and direct examined so that we can test their credibility, how well they remember things, if they have any potential bias against or in favor of any of the parties in the case, if they have any interest in the outcome of the case. This is why we favor in-person, live, direct testimony. However, some of our states recognize that when a child is involved in a prosecution or in any case, whether it's civil or criminal, that it might be overwhelming. It might be very difficult for that child to actually take the stand and relate and recall these events. And so there is something in Arkansas that's considered the residual exception, which says that if the child is not able to testify live, if a judge makes a determination that the child wouldn't be able to handle it or doesn't have to come in live to testify, that an adult to whom she reported this abuse, like the nurse who examined her or the social worker who discovered the bruises, would be able to testify on her behalf and say, this child reported to me that this male suspect caused these injuries and that her mother, in fact, knew about it and told her to say that the dog fell on her. That is a very, very narrow exception, something that is potentially controversial in criminal prosecutions, but something that is potentially available to the prosecutors should they need to head in this direction.
I wonder if that's an advantage for the defense in two ways. One, if this, again, young girl, presuming, again, we don't know how old she is, but if she were to take the stand, to have a defense attorney grill her and cross-examine her, that optics-wise could turn a jury off. So now you have somebody speaking on her behalf, or basically saying, I had a conversation with her. I'm a social worker. I'm a nurse. I'm a law enforcement officer. I spoke with her. This is what she said. Now you can be a little bit more aggressive as the defense attorney. But also, like you said, it's still a little bit of hearsay. It's, she told you this? You sure she told you this? Why exactly did she tell you this? Do you have a bias in recounting it this certain way? I wonder if allowing this to happen would actually be an advantage for the defense.
Yeah, Jesse, that's one way to look at it. I think you could say there is an advocacy advantage in that you can conduct a little bit more of an aggressive cross-examination when you have an adult witness, especially when you have a social worker or a nurse who are professional in their fields and can handle a little bit of a more aggressive line of inquiry. And you're absolutely right. Any witness who takes the stand should and will have their biases exposed or credibility undermined. That's exactly the point of cross-examination. I would push back a tiny bit, though, and say I think for the criminal defense bar, the objection to having an adult testify on behalf of child witness flies in the face of what we know as the Sixth Amendment Confrontation Clause. And again, if this is a criminal case, Ezzy, the mother, has a right to confront her accuser. And in this case, yeah, it's really sad, but her accuser is her own child. And so constitutionally, she would argue, the mother would argue, that I have a right to ask that child questions directly and not have those questions asked of someone who's only receiving the information secondhand and is testifying via hearsay. So I don't think that the defense would favor having an adult witness testify on the child's behalf, even if it gives them a slight advantage from an advocacy perspective, from an evidentiary and from a constitutional perspective. I think they'd rather have the actual complaining witness, the child, testify.
That's fair. That's fair. I get that. Talk to me what a defense would be, though. What would work in their defense? Because I'm struggling a little bit. You would say the injuries were not caused by this man, that my daughter's not telling the truth about what happened. You tell me.
Yeah, I think that there are a few very limited avenues that defense could go in. They could certainly claim that the male suspect didn't have access to the child or didn't have exclusive access to the child, that he was never had an opportunity to be alone with her and couldn't have caused these injuries without other witnesses. And then the defense would say, where are these other witnesses if in fact he committed these acts in front of other people? I think the other thing would be for the defendant to just claim a lack of knowledge and say these bruises were covered, or I didn't see them, or I certainly wasn't present when this abuse was happening, so I didn't know that it was happening, and had no way of ascertaining how my child was injured.
Problem is, if you take this child's word for it, or her daughter's word for it, saying the dog did this to you, that only shows a level of knowledge. That is trying to cover it up.
Well, that ultimately comes down to whether a fact finder, unfortunately, whether the fact finder believes the child.
Right.
And you have physical evidence of injury, but how those injuries were sustained and the cause of those injuries really will come down to a defendant said. I don't want to say she said, she said, but it really will come down to a test of credibility.
Talk to me about what the options are for her defense team, her defense, in the sense that Could she just plead guilty to this? First of all, from a human point of view, don't put your child on the stand to have to testify this. That's one way. B, you might have some sort of leniency if you decide to plead guilty to this rather than take it to a trial where, as I mentioned, you could be facing years in prison. What would a deal look like? What would pleading guilty look like in your best estimation? If you've looked at other kind of child or alleged child abuse cases or child abuse cases, what does it look like for someone, a parent, to plead guilty to something like this?
Yeah, I think it's probably a gut-wrenching decision. And you're absolutely right that one of the considerations is going to be, do I force my child to go on the stand and then have my attorney essentially cross-examine her and call her incredible and tell her that she doesn't know what she's talking about? So that is a huge consideration, or I hope it would be a huge consideration for any mother or any parent who is accused of abuse of their own child, or even allowing abuse to have been perpetrated against one's own child. I think that there are a lot of things that would go into the prosecutor's decision to either extend an offer for a non-trial disposition, meaning making an offer for her to plead guilty perhaps to some lesser included offense or for some lesser period of supervision or incarceration. I don't know what the defendant's prior record is, if she has any prior contact with the Department of Social Services, if there have been any prior allegations of child abuse or any prior involvement from the department with this particular household, if she's got any other criminal history, anything that doesn't have to do with abuse or child abuse. All of those things would factor into the decision of whether she pleads guilty, what she pleads guilty to, and how much of a penalty she could potentially face.
A lot of factors to consider right there, and we're still at the beginning stages of this. Listen, Professor Braccia, really appreciate you coming on. Thank you so much. I will tell you, I see your background, and it gives me, I don't want to say PTSD because I love law school, but it definitely is bringing back memories to my law school days, you being in that kind of room. So good seeing you. Thank you so much for coming on. I know this is a difficult case to talk about, but an important one nonetheless. So thank you so much for taking the time.
Thanks, Jesse. We always need continuing legal ed, so come on back whenever you're ready.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.